Okay, so welcome to the fourth day of the summer training school of the International Master Degree in Security and Human Rights. It's a special morning session because we have the pleasure to host both the speakers in person. So our first guest speaker this morning is Dr. Victoria Vajtovic. Victoria is assistant professor in sociology at the University Ca' Foscari in Venice. So she's joining us from Venice, and previously she was a postdoctoral researcher at the University of Milan and worked as a policy officer at the European Council on Refugees and Exiles in Brussels. She is a lawyer. She holds degrees in political sciences, European studies, and sociology, and she obtained her PhD in migration studies at the University Paul Valéry Montpellier III in France and at the University of Porto in Portugal. So we are really glad to have Victoria with us today to shift a little bit the focus. We started from definitions, we moved on to key legal issues connected to community sponsorship and competing models. We dealt with non-discrimination, additionality, and other relevant principles. Then we moved on to the comparative analysis and studied different models of community sponsorship, resettlement, and legal and complementary pathways. Today is the day in which we will reason around the public-private partnership in cases of mass displacement. And in particular, we will focus on the case studies of Ukraine. So what was the response by the European Union to the crisis in Ukraine, to the war in Ukraine in terms of reception and integration of Ukrainian refugees. Therefore, Victoria will first of all illustrate the working of, the functioning of this piece of EU legislation, the Temporary Protection Directive, and then we will move on with our second speaker with further insights on the Poland model, or the Polish model of reception and integration. Thank you very much for being so numerous also in this fourth day, notwithstanding the hot weather outside. And I'm really happy to leave the floor to Victoria and to share the screen for her.
Thank you very much, Daniela, and good morning, everyone here in person. It's really a pleasure to be part of this wonderful training. And of course, also regards to all of the colleagues joining online. Thank you very much for your attention. And many thanks to the organizers for the invitation. Thank you, Daniela, Marilu, for all of the help and assistance and for this kind invitation to share the, it's okay, I think we can stay like that, right? I just click here. To share some of the highlights on this topic, which is the topic of the EU's response to the displacement from Ukraine. As Daniela kindly introduced me, I'm a researcher right now at the Ca' Foscari University in Venice, where I continue from the academic perspective to study these issues now from a more longer-term perspective. I study how the transition out of temporary protection directive actually occurs into other legal statuses. But on that, come to speak to me about it in some 3 years when I actually have something more meaningful to share, and we'll be very happy to share the outcomes of my ongoing research. But obviously, today I will be also sharing with you the insights that I've learned during my previous work in Brussels at ECRE, European Council on Refugees and Exiles, which is a pan-European NGO, which coordinates the work of more than 140 organizations assisting displaced persons in Europe at external borders. And this is the place where I work on the Temporary Protection Directive, I was following the development since the beginning of the displacement, since 2022. So I would like to obviously give credits also to my previous employer for the insights that I will be sharing with you today. Please do not hesitate to raise your hand, interrupt with questions during the lecture. This obviously also relates to people joining us online. I suggest you can just simply unmute yourself and ask your question. I would like to start with it's okay. Shall we click on I would like to start today with simply giving an overview of what is Temporary Protection Directive. We talked so much over the past years about it in the news. We hear it from the media. Academic debate has been so much focused about it that I would just like to untangle together with you what is this tool and why it takes such a specific role within the Common European Asylum System. We will then turn towards the specific moment of activation of Temporary Protection Directive, of its first ever use that we saw in March of 2022. We will then unfold some specificities of this tool, specificities of the implementation of the TPD. We'll discuss certain gaps, also obviously the benefits of this tool that that allowed us to see such a positive response, unprecedented and very positive response to the displacement. And I would conclude with the discussion of the way forward, the exit options, because we should not forget at the very beginning that this is a temporary tool, right? It's designed to provide a temporary measure, temporary assistance. And we will also discuss together about the lessons that we can learn also with regard to the help to other displaced persons. And here I would really be very, very eager to hear your views on the topic. And I invite you to also already start reflecting as the presentation unfolds. Let's start with some background. What is the Temporary Protection Directive? Any views in the room? Any information? What do you think it is? Why we've talked about it so much? Any thoughts about it? When you hear TPD, Temporary Protection Directive, what do you think? What do you think of? Please don't be shy. Just go ahead with your views. For sure, everyone in this room heard about it, right? Please go ahead. Just unmute yourself so that the people in online can hear.
I have not heard about it, but from the sound of it, I think that it means that maybe a refugee could be temporarily protected in one country before he or she goes to another one, maybe just some intermediary resettlement place, maybe, I don't know.
Okay, thanks a lot. Any other views? Any other opinions? Well, then we go ahead with untangling what it is actually in practice. You pointed out very correctly that it's about the protection of refugee, right? It's a protection of displaced population. And this is how it was designed precisely in the 90s, is as a response to the conflict in the Balkans. The European Union saw the utility in designing the tool that would actually guarantee the immediate access in the events of the mass influx. And provide the very minimum standard of the protection. And this is how the directive in the course of the couple of years of the negotiations and discussions at the EU level was finally adopted and got this name of the directive of 2001, which should be applied in the event of a mass influx of persons. You can see the extract on the slides of exact legal definition, outlining also the procedure, right? The procedure for the triggering and the character of the displacement that this specific tool is designed to address. And here we talk obviously about the multiple interests that the legislator pursued. On the one hand, obviously, the protection of a big group of people who is facing the need of displacement, need of protection. But at the same time, also the need from the legislator to protect the asylum systems from the collapse. I don't know why I cannot change the slide, sorry. Yeah, like that, perfect. Here we are with the next slide. Any guess again from you? We have this tool since 2001. We know that it was first activated in 2022. Why 20 years of oblivion? Why 20 years of non-activation? Any thoughts? Also, because I think we should highlight that Temporary Protection Directive is a part of the common European asylum system, of the common rules at the EU level about the treatment and protection of the displaced people. It's not something unique, existing there in a vacuum. It's really an integral part of the acquis. Why we haven't seen activation over the past 20 years, even though obviously there was displacement, there was a need of protection. Any thoughts on that? Also, perhaps online? Please. If you can maybe try just to use the mic.
Yes, it's working. From what I've been observing, the Commission had a, how can I say, more neutral position about asylum and migrations, and it created a lot of problems. And we have been seeing the switch in the last 2 years that delivered, allowed us to see the delivering by the Commission of the Pactum, changing from a directive approach to a regulation approach. So I think this is some kind of reflection of that kind of position when the Commission allowed to the member states to have more freedom about approaching all the migrations and asylum topics and issues in general. We had the chance to see that it was not working, of course, because we have seen the pressure, especially for the most exposed countries like Italy, for example, the external, so-called external borders of Europe, of course. And so this forced somehow the Commission to have a more strict position, reflected in the shifting, as I said, from a directive approach, which of course leaves more space and room to the member states to adequate somehow the general rulings and how can I say, basic principle that cannot be denied, of course, to the local needs. But this created too much difference between the states and created a lot of issues that now we needed to face, of course. And so I think that it is related somehow. I don't know if I'm right, but I am.
Yeah, thank you so much for this opinion. I mean, I completely agree with your view, and this is certainly one of the points that we should discuss, the fact that this is a directive, which means that while obviously this is the legal tool that applies to all member states, because obviously it abides the countries to follow the law, abide by the articles, the provisions, the standard. Since it is a directive, the member states have a lot of discretion about how to actually implement it, particularly in the social sphere, particularly about the modalities of granting the access to socioeconomic rights, employment, housing, social welfare. All of these things are subject to the decision of any specific country. We will talk a lot about the insights further from Johanna from Poland, and you will see that this is how one of the most affected countries reacted. But then when we talk about Italy, we can see a lot of discrepancies about the access to accommodation, for instance, right? It's one of the most critical standards. So definitely, I'm here completely here with you regarding the point that the decision makers perhaps thought that, since it's a directive, there will be a lot of the discrepancies, how the standards are implemented in regards to this displacement. I will just add to your reflection, perhaps a number of
please go ahead. There is also Ala in the chat.
Okay.
saying that maybe it's because of the complexity.
Complexity. Certainly, yes. Thank you very much for this suggestion. Again, another brilliant idea that I perfectly understand and also support. Complexity of the procedure, as I also put on the slide, you know, of the activating of the tool, because the directive tells us that there is a need of the proposal of the Commission, who needs to evaluate and suggest, okay, there is a situation of mass influx. There is a valid grounds for triggering of this specific tool within the toolbox of the EU rules, and now we see a lot of developments also with the pact. No, this is a situation which should be addressed specifically by this legal instrument. Then the Council needs to vote. All of the member states need to take a decision by qualified majority, which indeed is quite a complex procedure. And we need to understand that this all should happen quite fast because there is a situation of mass influx. People have been already displaced. They already find themselves either on the border or already in the territory of the EU, as was in case of Ukraine displacement, because we also know that prior 2022, Ukraine already had visa-free regime with the EU, which allowed displaced persons immediately have access to the territory. Another factor that I would like to add in trying to understand and explain why Temporary Protection Directive has never been activated for 20 years is this argument that exists in the scholarship and among the policy makers that it's too generous. You know, there is this direct access to all of the set of rights, and if we activate it, all of a sudden, all of the people would want to come. And as your colleague rightfully mentioned, there was even the discussion about the redundancy of the tool in the course of the negotiations of the new pact on migration and asylum, which was happening precisely in the time of the activation of the Temporary Protection Directive. These negotiations have been happening for years. On the one hand, with a trend towards more stricter rules and more regularized approach, because as you also rightfully mentioned, we now see instruments being transformed from directive to regulation, which means that EU member states do not have a lot of room for creativity as to affording the access to rights. It's direct indication of how things should work. As opposed to directive where there is some room for flexibility, you know, and the approach mics in the room are
Okay.
off.
Okay. Can you hear us? Yeah. Did you lost the entire explanation?
Yes.
Yes? Okay. No. Okay. Okay. So maybe yes now. Okay.
Okay,
Let's go
perfect.
ahead. Yeah, maybe you can collect the questions
Yeah.
at the end.
We will collect the questions in the end and we will go ahead with the presentation. I would like to remind you that you will have access to the slides also after the lecture, and you will have my contact details. So in case you would like to continue this conversation, you are very free to reach out to me also online. So we stopped at the point of 2022, where the EU decision-making, very complex and difficult structure, decides to respond to this specific displacement in Ukraine, to the war in Ukraine, which started in February 2022. In response to that, there was a decision to finally activate this tool, the Temporary Protection Directive. It was found that the situation corresponds to the Article 5 of the directive, which sets out this need for mass influx of displaced person, in this case of Ukraine. And we know an extremely speedy procedure, unprecedented, unanimous positive decision from the member state, unanimous agreement under the very strong leadership of the European Commission back then to activate this tool, to grant this immediate access to territory, to legal status, and to the right. Why it was done so? Well, as I already explained, there was we know that there have been millions of people fleeing from Ukraine into the EU. So it was established that the situation of mass influx is there. Another important rationale was to alleviate pressure on national asylum systems and to offer a quick and effective assistance. We know that within the so-called normal asylum procedure, every individual has to lodge an individual asylum application, which then is considered on the merits and given all of the personal circumstances, which can take, in fact, years, right? We are now find ourselves in Italy, the country where this can take literally, it's not even a matter of months, it's a matter of years. In this case, we saw that there was an extremely flexible approach to recognition of the need, of the protection need. Well, in fact, it was really enough to prove that a person was residing, a Ukrainian national was residing in Ukraine prior to the outbreak of the war. The protection was also afforded in line with the directive's provision to the people who had permanent residency in Ukraine, who were not Ukrainian nationals, but they were residing in Ukraine based on the permanent residence grounds, and also the family members of Ukrainian citizens who were residing in Ukraine prior to the war. We also saw a very flexible approach by the member states. In some cases, the administrations decided to extend the protection to the people who were already in the EU when the war started. So we really just with these examples to give you an idea how flexible, how fast the response was, how quick and effective this immediate assistance was. And again, just to highlight the discussion that we already had before, since it is a directive, the member states had a lot of flexibility as regards to the standard and mode of granting access to the rights. And once again, this is a very critical point that I want us to remember, that this is about a group protection. So the displaced person did not have a burden of proof explaining that, there is this situation, this is why I'm asking for protection, this is why I have the right to access legal status, rights and protection in the EU. Just the mere fact of the established displacement factor in the Ukraine was already enough for the person to claim the assistance. For us to have an idea of the current implementation status, the directive talks about a very short-term temporal scope of it, right? We first saw its activation for 1 year. So in March 2022, the directive was activated this regime of temporary protection was triggered just for 1 year. Obviously, there was a lot of hope that the war might end, that there will be conditions for the people to return. Because again, this is a temporary measure aimed at providing access to territory, legal status, and the minimum standard of rights. We are not talking about something that is designed, to sustain there for many years and to give people long-term regularization path in the EU. No, this is really to address humanitarian needs. The very strict reading of the directive, in my humble opinion, and I know a lot of colleagues in academia, but also policymakers, practitioners, lawyers share this view. The reading of the directive talks about 3 years, right? So first it is triggered for 1 year, and then if the conditions in the country of origin persist, so in our case, if the conflict is still there and it still is inducing the displacement, it can be extended following the same mechanism at the EU level in Brussels by the policymakers. You know, there needs to be a proposal by the Commission, then there needs to be a vote. This can be extended for another 2 years. So everyone thought at the beginning that we are really talking about 3 years maximum regime, you know, and then some other possibilities should be explored. Either we see that the condition again in Ukraine improved, it's safe, it's durable, people can return home, or there is a need for alternative option. And one of these options is obviously asylum, and we will talk about these exit options a little bit later. So we have the triggering for the first year. We know that the situation unfolded the way it did. The war didn't stop even until up until today. We saw consequent extensions for 3 years, and curiously, after the 3 years term was expiring, we saw yet another proposal by the European Commission to extend it for the 4th year, which created a lot of debate, scholarly debate, but also practitioners' debate. The Commission, the European Commission justified this by the broad interpretation of the Temporary Protection Directive. We know that it has never been triggered before, so there is no previous knowledge to borrow. You know, it's not that we can go back and see, oh, okay, in the past, in the history, this is how it was used. There is no practice. This is the first time everyone was dealing with that. European Commission justified it by the fact that the conditions persist, and therefore it can be extended for yet another year. Leaving us with a situation where it was active until March 2026. Well, again, we know the situation is largely the same. The conditions, the reason for the displacement persisted. And literally weeks ago, we saw yet another proposal, similar proposal by the Commission to extend it for the 5th year, so up until March 2026. I would like to also at the end hear your views on that, because we know the text, right? We know the text of the directive, which talks, Article 4, if you're curious, Article 4.2 talks specifically about the time limits. And now we find ourselves in the reality where it has been proposed for the 5th consecutive year. If you have any views on that, you want to share, discuss at the end of the presentation, I'm very happy to. Just to give you a glimpse, if you haven't heard in the news or you are not simply following closely the topic, it has been positively evaluated by the Council, and basically what we are lacking is just the very formal last approval by the heads of the states, which everyone is expected. So this is something that we can kind of take already for granted as a fact that this is going to happen, that the extension of the temporary protection regime is going to be lasting and be valid at least until March 2027, leaving us with 5 years of the temporary protection regime being active at the EU level. Together with this proposal for the extension for the 5th consecutive year, Commission issued the communication to the member state, highlighting the need to look for durable solutions and some sort of a common approach to exit the temporary scope of the directive. Because we know that 5 years is a lot, right? A person residing in another member state, especially with the children. And we know that the characteristic of this displacement is that there has been a lot of women with children who had to flee. Many kids were enrolled in school, people found the job, started studying the language. So we can try to imagine, and perhaps some of you in the room also have similar experiences, right? After residing for such a long period of time, there is a need for some longer term vision, right? What is going to happen next after all of these short-term yearly extensions? We will also come back to this a bit later, and I would like to also know your views. How do you see the exit? How do you see transitioning out of the temporary protection? What would be your suggestions regarding the options of post-temporary protection? I already briefly touched upon the scope of the temporary protection. So what actually it covers? Which category of people? Obviously, Ukrainian nationals, as I said, who have been residing in Ukraine prior to the outbreak of the war, also stateless person and national of third countries who had permanent residency and also international protection in Ukraine, and also other valid residence permits in Ukraine. What kind of rights temporary protection grants us? So if you find yourself as a temporary protection beneficiary, what are you entitled to? So obviously you have a right to the residence permit. You can really obtain the residence permit to exercise your freedom of movement, exercise access to other rights. You can engage into employment and also self-employment. And again, I'm looking at Johanna because she will really give you all of these real insights from a most affected country, how it actually worked in practice, what are the challenges, because this is how it was designed in theory, and you will really have the unique chance to learn how it works in practice and what have been the developments over the years, how it evolved the protection regime. Beneficiaries of temporary protection have also access to accommodation, welfare assistance, medical assistance. Unaccompanied minors have a right to guardianship. And also, critically, I would like to really draw your attention to the fact that temporary protection holders have the right to apply for international protection. This is something that the directive tells us. Obviously, it is a tool designed to alleviate the pressure on asylum systems, which in some member states we know already had a lot of struggle, had a lot of struggle to cope with the number of asylum applications. Next slide. And yeah.
Again?
I think this one is fine. This one is, yeah, perfect.
Yeah.
Thank you. Yeah. Perfect. We are just checking if everything is also fine online. So the possibility, the right to apply for asylum is also there. We know that some member states adopted different practice. They decided to freeze the possibility to apply for, well, it will not be very legally correct to say that, and there might be some future lawyers in the room, so I don't want to say something that I will be then brought liable for. The possibility to apply for asylum is always there, but some member states decided not to consider these applications as long as temporary protection is valid. So basically the logic behind that is, okay, once this regime ceases to exist, we will come to your application for international protection, and individually we will evaluate it with time. But the right is there, and this is one of the opportunity and right really enshrined in the provision of the directive to lodge the application for international and other forms of protection. Since we started our discussion with the fact that this is a directive, right? I mean, we know the standards, we see the design, we see the idea, we see the set of rights that are afforded by any person who is recognized as temporary protection beneficiary. How does it work in practice, since it is not a regulation? It is a directive. I decided to bring an example in the area of, I will just give a moment to your colleagues to exchange. I decided to give an example of us. We would be very happy to also discuss together if there are any reflections in the room. We are very happy to collect the feedback. I decided to give an example of the housing because this is also the side project that I have been doing, and I'm very curious about, because obviously this is a fundamental right. This is a fundamental socioeconomic right that is very much entangled with any other, right? I mean, if you don't have the house, the accommodation is not a mere shelter, is not a mere roof over your head, is also a dress, is also your registration, the place of your registration, which then is entangled with all of the other rights, employment, education, and so on and so forth. The topic of this summer school is also private-public partnership, right? How these two spheres interact in the area of protection. And I just decided to give you an example how this cooperation, drawing on the example of financial support for private housing, because also important to highlight that the temporary protection holders have the right and freedom of movement. They are not restricted as other asylum seekers to a specific place of registration, and even the country. This is also a very unique factor of this response. Really, there is a lot of freedom with regard to in regard to the place of residence and registration, and private housing was one of the key factors which allowed for the very efficient response to this displacement. How did it work in many different member states? You can really see that the source is Asylum Information Database of European Council on Refugees and Exiles. You can also find all of this information online, and the link to this source is provided in the suggested readings on the Google Drive. Well, as your colleague started at the beginning, we see a lot of discrepancy, right? In some member states, these frameworks of financial assistance to access independent houses simply do not exist, while in others they do. I suggest we'll take a look, for instance, in Italy, the country that we are right now, some of us, also colleagues online, I believe, might be joining from other countries. Let's take a look at Italy. There is financial support to access independent accommodation, which in my view is also critical when we talk about extended, protracted displacement. Like, we are already talking not about immediate humanitarian response. We are now talking about the possibility of the 5th year of the displacement. And here, obviously, the access to private and independent autonomous accommodation is the key. We see that the financial support was provided. We see the sum of 300 euro per adult. Unfortunately, in this database, we cannot really understand for how long, we are talking about the duration in the third column, for how long this assistance has been provided, but it's there. We see that it's very different in some other countries, right? With regards to the sums afforded, but also with regards to the very existence of this support. And this is just to bring us back to the discussion of really discrepancies and lack of harmonized approach across the EU. I suggest we move for the sake of time and leaving sufficient time also for the discussion at the end. We move to other characteristics, which in fact we already covered partially. We talked about the temporal scope. We discussed that while it was triggered initially for 1 year, well, now we are facing a very different reality, right? We are facing the extension until March 2026. Important to emphasize that the cornerstone of the instrument is really the solidarity among the member states, right? The need for the balanced effort. And one of the reasoning for non-activation of the restriction on the freedom of movement is precisely that, to allow persons to move from Poland, from other bordering countries onwards, to join their extended family. We know that also there was a lot of Ukrainian diaspora already in different EU member states, including Italy, by the way, before the war started. So there was this idea that, let's give the right to join the network, to seek more suitable professional opportunities, and simply to exercise the agency, right? Something that some people can take for granted, simply the possibility to choose the country you live in, the country you want to work and establish yourself. Solidarity is critical. And finally, the non-activation of the Dublin rule. Again, if we draw it to a specific legal provision, I refer you to Article 11. So it is there. It is designed as part of the TPD, this general approach of Dublin. Are we on the same page about the Dublin rule? Otherwise, I just yes or no quickly. Okay, the Dublin rule basically is a rule within the traditional understanding of the asylum system, which states that the country responsible for the consideration of the asylum application should be the country of first entry, right? So basically, if, let's say, according to the strict reading of the Temporary Protection Directive, according to the Article 11, if I am a Ukrainian, I flew to Poland, I will have to stay in Poland because this is the country I first accessed. However, the policymakers, the decision makers decided not to activate, to freeze this article, okay, to allow this onward movement. That's why many people who first came to Poland, they actually could go onwards, Sweden, Italy, you name. And this is really unprecedented characteristic that we have not seen so far in any other response. This is something really unique and really, really beneficial. I mean, not only for the protection beneficiaries themselves, but also for the member state, because it promotes this solidarity, promotes this shared. Okay, sorry.
Yes, sorry. I think it is necessary. Otherwise, the solidarity mechanism cannot work because, of course, people. Okay.
Maybe if you come.
Okay,
here,
here?
Yeah.
Yes, I've been really impressed about the differences between the countries, and I was reflecting on how crucial is the capability of covering the expenses related to this measure, because of course we know that we have many differences in the welfare system and also the wealth of the single states. So I think this may create, of course, ulterior imbalances because migrants may be searching for the countries that are wealthier, or otherwise the one that can allow a better, how can I say, set of protections. Also considering the healthcare system, we know that Italy is really a benchmark worldwide. So this create especially relating to the extension of the period, which may be really critical for Italy, for example, for the overall balance of the public costs. I think it is really crucial what you mentioned, because otherwise it is applying the Dublin rule, of course, people coming in Italy, which is one of the it used to be the first choice for some kind of corridors. We know where we are in some kind of, how can I say, best fluxes, because we are at the very forefront of migration. So for our country in particular, I think this is really working, and it can allow an overall balance and subsidiarity mechanism really, really working and effective for EU. Thank you very much.
Thanks a lot. And this is something also very curious regarding this displacement, right? That it completely changed the most affected countries, right? You gave an example of Italy, and you will hear the example of Poland. It basically turned the whole system upside down. And obviously, the differences in access to rights, in social welfare is one of the key challenges, because we see different standards, but we also have different degrees of access that were afforded. Again, if you're curious, you can go to the various reports based on Asylum Information Database, and you will see how different this access is. In some member states, actually, in fact, people displaced from Ukraine don't even have access to social welfare at all, I have to say. Obviously, this is a minority of the states, but this is still an existing problem, practice and the problem, because we cannot take for granted that everyone can, immediately integrate into the labor market. There are also people who simply cannot do so, have caregiving responsibilities, and so on and so forth. Another challenge of this specific tool implementation that I would like to outline is the lack of facilities that are adopted also to the needs of people with disabilities, especially the children. We see the practice of the prolonged stays in temporary protection reception centers, and really the lack of transitioning into the autonomous and independent accommodation, for instance. And also one of the biggest problems, especially at the beginning of the displacement, that was unveiled by lawyers, by human rights defenders, is the fact of the lack of recognition of disability certificates, because Ukraine has a very different system. And I think this is also an important factor to underline. Briefly about the key challenges that we also already touched upon, the dilemma of temporality. We talked a lot already about it. How temporary is temporary, simply, how temporary should be the temporary protection directive. Again, the strict reading of the law talks about 3 years. We now see the stretch of the temporality. But is it beneficial? Is it beneficial, and for whom? For member state or for the beneficiaries themselves? I'll leave you with this question, just to reflect also after this lecture. And this phenomenon of extension brought up another big challenge, another legal debate about this extension. One of the leading scholars in the field, Meltem İneli-Şiger, the academic in Turkey who really is an expert on the topic, she talks about this phenomenon of extending the tool also as a risk for the extension of other instruments, right? Here we find ourselves in this situation where temporary protection is extended for the benefit of displaced person. So we know that the people will have longer access to status and rights. But what if this extension of temporary measures, maybe restrictive measures, is also applied in the future? You know, would we be so also positive about it? And this is also something that, you know, should draw a lot of attention and thinking from our side. Obviously, numerous lessons learned. Effectiveness as an emergency tool of temporary protection directive and the regime cannot be denied. And it showed its value in the situation of the large-scale crisis and the large-scale displacement. We discussed really a lot about the need for coherence. Since it's a directive, there is so much discrepancy with regard to the, the rights and the level, the standard of rights of force. And so obviously there is need for more harmonization, more coordination among the member states. There are multiple integration challenges, inclusion, if you will. We are now exiting we have in fact exited the very immediate, humanitarian emergency. We are now in the situation of which starts to become a protracted displacement. And there is obviously a need for longer term thinking. The policy flexibility again comes to the basket of a very flexible, very positive aspects, because it really allowed for various adaptations and the creativity and flexibility from the member states. Since we touched upon the normal, asylum policy at the EU level, I just, couldn't leave without not mentioning the new set of laws, the new developments that we have introduced by the new Pact on Migration and Asylum. It's a set of the new reformed laws that are going to govern the whole asylum, the area of asylum and migration at the EU as of, in fact, summer 2026. But I know that some of the instruments will also enter into the force a bit early. I'm looking at the real practitioner here to validate my words. Let's take a look there, let's take a look how solidarity will be understood within these lines, and how the temporary protection directive, how lessons drew from its implementation can also inform the implementation of these new rules. Obviously, the solidarity mechanisms continue playing a very important role there, and there is a lot of discussion, there are a lot of sophisticated mechanisms as to how distribute this responsibility. I will spare you, I think, for the sake of time, of the very sophisticated mathematical explanations that the European Union came up with, but if you're curious, again, we can stay in touch regarding that. Solidarity remains to be at the core. There is a lot of discussion how, in the event of future displacement, how this should be managed. Flexible solidarity that we saw with the implementation of the Temporary Protection Directive, how this can be adopted in regards to other groups of displaced persons. Well, first, we saw that the freedom of movement afforded to the displaced person does not really harm anyone. Containing people in a specific place is not really beneficial for neither for the system nor for the displaced persons themselves. And we see some room for easing this burden that is there. We see it in asylum migration management regulation and some other tools. There is a lot of discussion right now about this flexibility granted to the member states to adopt broader definition of family ties, for instance, so that the displaced person can exercise this onward movement and really exercise their agency as to the place they will be benefiting from the protection. Same relates to the broader interpretation of the concept of dependent person, which can also allow for, for this unification, for mobility, for agency exercise. And also wider use of discretionary sovereignty clauses, which means that member state, other than the first one of arrival, can also take charge of the displaced person, and the relocation, the more fair responsibility sharing, the onward relocation can be possible. We are almost at the end. I would just like to say really a couple of words so that we have sufficient time for the discussion and for questions. Would like to say a couple of words about post-temporary protection options. What are we facing now as we're dealing with a very temporary regime, right? Well, the directive itself already suggests some options to us. The directive talks about the return, the voluntary return, with very important conditions, with a condition of safe and durable situation in the country of origin, right? Obviously, now we cannot really talk about it. The European Union, the European Commission have a lot of expertise and experience with that. Also, there are extensive guidelines and experience by the UNHCR. So all of these should be taken into account before these programs are put in place. Application for international protection, we already talked about it. I will not take more time discussing this. This is an option given by the directive. And the directive also tells us that all of other legal permits available within the national legislation could be of use in these cases. So basically, people should be allowed to transition, to convert their permits into, let's say, work-based, study-based, family-based permit for the sake of, longer-term inclusion, longer-term stay, in case a person is not able to, or simply does not want to, after 5 years, to return to Ukraine. We have witnessed a lot of the discussion on the EU long-term residence directive application. There are a lot of legal questions still whether it is a relevant tool, because there is a lot of unclarity whether the years spent under the temporary protection can be accumulated and used in order to apply for EU long-term residency. Obviously, all sorts of humanitarian tolerated states should be also brought into the discussion while thinking about longer-term options and other potential forms of regularizations. So I think here we are with the conclusions, and one of the important ones is that indeed this response completely, shaking the traditional approach to the displacement by the EU. We saw a very creative, very unified, full of solidarity, creativity, and flexibility, a positive approach, which was also characterized by a lot of coordination among the member states. At the very beginning, the Commission established the Solidarity Platform, where the member state had the possibility to exchange on a weekly basis at the beginning. Just think how difficult it is from the practical standpoint to bring the representatives of so many countries to debate on very technicalities of the regime. But this is possible. We saw that this is possible, right? To have this coordination, to have this ongoing discussion on such a regular basis on so many different aspects. The Commission also adopted immediately a 10-point plan for the member states to follow to efficiently respond to the displacement. Again, we're talking about March 2022. We're talking about the days after the outbreak of the war, just to show how fast it was, and we see how that it was actually possible, with this kind of the response. And we saw a very different from the traditional approach situation. Instead of the containment at the borders, we saw freedom of movement, we saw access to the territory, we saw possibility of onward movement. And again, as your colleague already highlighted, we really saw the complete change of the most affected member states. And again, I look here at Johanna, who will discuss how these new member states responded in detail. And I leave you with the question about the lessons that could be adopted for other displaced persons. After all we discussed, and also based on your perhaps academic knowledge or practical perhaps experience, would you share some specific point that you believe is important to borrow from this experience of the response to the displacement from Ukraine, to help, to assist, to provide assistance rights to other migrant groups in the EU? I thank you for your attention. I'm available to discuss any questions that you have also beyond this specific topic, and I would like to hear your views on the question that I asked. Thank you very much.
Thanks a lot, Victoria, for this very, very insightful presentation. I would have some questions also for you, but let's first leave the floor to the audience, both here in presence and online. Let's see if there are questions. Let me check. I see some people in the chat. Okay. So I'm showing you the chat because there are some questions here. Of course, I mean, guys, we have time. So what I suggest is you to, speak instead of writing the questions, apart from in the case you have a problem with the connection. I know that Ala may have some troubles with the connection, so maybe I will read his question for you. Can refugees choose what countries they want to travel after Poland, even if the other country doesn't provide asylum options for Ukrainian? I think that must be a previous agreement. So this is the question by Ala. And then maybe Manase and Ripi, they want to speak and to take the floor. So
Shall I first answer to the-
yeah.
Thank you very much for your question. If I understand correctly, you are asking about Ukrainian displaced persons, right? Yes, a temporary protection holder can choose a country, Ukrainian displaced person can choose a country where to benefit from protection, even after Poland. As I mentioned already, the usual Dublin rule, which is part of also temporary protection directive under Article 11 was not activated, which means that there is a possibility even after having been benefiting from temporary protection in Poland, there is a possibility to go to other member state and to register for temporary protection there. Obviously, there are a lot of practical challenges related to that, and we saw it with a very difficult administrative procedure, because some member states then requested the proof of deregistration in the first member state, and then we saw also that some member states were simply not issuing any proof of deregistration. So there were a lot, just in a nutshell, there were a lot of implementation issues. However, the right is there and it has been exercised extensively. We saw really significant onward movement. Thank you. I hope I answered your question.
Thank you. Let's see. Manase, do you want me to read the question or do you want to speak?
I think you can just read the question.
Okay.
All right.
So regarding the ongoing war and the desperation of the Ukrainians, Middle East politicking silence and inaction of the UN, do you think the EU need to push for permanent solution for the recognition of the Ukrainians as refugees, for a more responsive action and better practice? So this is the second question.
Thank you very much for your question. This is not just my opinion. There is a lot of debate and discussion on the topic, basically commonly agreeing that obviously there is a need for longer term solutions, and not in single terms, but multiple longer term solutions. There is really a need for a range of the option for persons displaced from Ukraine to choose from and to make available upon the expiration of the temporary protection regime. We discussed at the previous slide what are the options currently available. And obviously, as we are moving on towards the 5th year and the 5th year of this temporary regime, the need for more permanent, for more durable, longer term regularization options are evident.
Yeah, I think we can all agree with this statement. Ripi, and then I see Abdu.
Yeah, thank you so very much. The presentations was really, really insightful. This is basically not a question, but it's a comment that I have with regards to the directive. I believe there is a need for the directive to sufficiently capture when it comes to protecting the differently able persons, most especially, like you said in your presentation, the directive is geared towards protecting the displaced individuals, most especially from Ukraine. But again, like you mentioned in the challenges of the directive, differently abled individuals are not sufficiently protected under the directive, but I believe there is a need for the differently able individuals to be adequately protected as far as the directive is concerned. So basically, that is one of the the problems that I've seen in the directive. So I think there is a need, for us to really discuss about how adequately we can, protect the differently able persons as far as the directive is concerned.
Thank you very much for this reflection that I, of course, share very much, and that's why I concluded my presentation with suggesting a number of the lessons that can be learned towards, other displacement. And I think your question of why it was never applied for other migrant group is very valid, and I share this question. I don't know who can give us these answers, but I think we need to still ask them. And I also suggested some literature. Some scholars actually suggest their views on that, and they talk about factors of race. They talk about factors of politics. They talk about factors of geography, also socio-demographic aspect. Also, there is also, there is also a factor of Ukraine being a candidate country on the path of accession to the EU, on the path of becoming a fully fledged EU member state, which we cannot also omit from this debate. But really, thank you for this question, and I hope that some of the literature that I provided can, can provide some of the views explaining that. And indeed, I also touched upon the fact that it was with great pity, I have to say, that we observed a very different direction of the negotiations on the pact, right? We saw this very positive approach, very flexible approach with activation of the temporary protection, but we also saw many instruments of the pact and the new legislation that is coming into the force regulating the asylum matters going into a different direction, and towards more restriction. Obviously, not all of the tools are going to implement stricter rules, but some of them definitely will. Thank you again.
Thanks a lot. There is Farah here, but also other two questions from remote. One is a follow-up by Ala. One other thing, let me see if I can scroll down. Yeah, maybe. No. So, yeah, I will read from my screen. So from Ala, people with disability, especially children, often don't have good places to stay. What's being done to fix this and make sure everyone gets the support they need? I'm reading also another question in the chat for collecting some. It's by Deng Todd Deng. As you may be aware, of refugees are integrated in some parts of the member state, last for a short period of time. Do you think there is a need to improve or revise some of the approaches, model flexibility that could favor them? This question then is not very clear, so I kindly ask you to take the floor and explain yourself. Thank you. And there is also a question by Abdu and then Farah. So Abdu, would you like to pose your question, please? And also Deng.
Okay, thank you very much. I don't know if I am audible.
Yeah, we hear you. Please go ahead.
Okay, thank you. It really impressed. The presentation is nice. That's why, so it lead me also to have more understanding on how the refugee has been, being integrated, and some of the member states they do some of their approach, so it lasts in a short period of time, while to my opinion, I'm thinking is it could not help because being forced to flee away from your own country, so meaning the situation is very deteriorated. So to make it brief and short, some of the member states they use some of their approach whereby the refugee given a short period of time for them to stay in. Do you think that there is a need to revise or improve, the flexibility of the approach that could favor the refugee where they flee to, the host country? Thank you. If you may understand or if you may get me well.
Thank you very much for your questions. I really hope that I grasped them correctly. I will try to, and also for reflections, because I think part of your interventions was also, sharing your own reflections, which I very much share. Answering the first question on the vulnerable populations and particularly children, what have been done in member states to address their needs? What I can tell you from my knowledge on the topic is that the flexibility and the recognition of the documents was key in assessing the needs. In this specific case, we know that many member states did not adopt this very strict, rule of providing certain documents. There was really, really a lot of flexibility in this area, not without the implementation gaps. Unfortunately, I will not be able to give you the overview, of the member state practices, but there is a lot of information on that. If you are interested specifically in this topic, really, you are very welcome to consult the Asylum Information Database, where you can see the country reports and really specific practices regarding that. Second question, as far as I understood correctly, is about the speedy access to the status and rights and inclusion under the temporary protection status and temporary protection directive, as opposed to protracted stay and protracted procedure, asylum recognition procedure. Well, honestly, I don't know even what else I can add here. I completely agree with you, and this is one of the most evident discrepancies in the system, right? In the common European asylum system that we have. And obviously, this positive example should be applied to other migration, to other displaced persons groups. And here, immediate access to employment under the temporary protection is one of the most evident example. Perhaps that in many countries, there is the containment period. There is a period where the applicant for international protection simply cannot work, cannot access other range of socioeconomic rights, cannot even contribute to the, to the economy of the host state, because there is no right to do so. Why don't we apply the positive example that we saw? And we know that now the employment rate, the inclusion rate of the Ukrainian refugees in the EU is extremely high, also thanks to this unprecedented measure and this rule. So obviously this is one of the factors that hopefully will guide the implementation and the room for flexibility that is given to the member state. And I know that there was a question also in the room. I don't know if you can hear me. Yeah, yes, I think. Come here. Okay. First of all, thank you for your presentation. My question actually was about, we saw what happened in Syria after the falling of the Assad regime. And from the first day, from day one, European state and stopped receiving asylum applications from Syrian people. My question will be about what if we are living in a crazy world? We don't know what will happen tomorrow. What if Trump decided to end the war in Ukraine? What will be the mechanism to end the temporary protection? Yes, exactly. I don't think it will be like the way European states and these
how they stop processing asylum application from Syrians. And I know they can still apply for asylum, Ukrainian people. And maybe there will be a voluntary repatriation. But still, we don't know how they will end the whole mechanism of temporary protection. It will be ended by the European Commission, but still, we don't have a lot of information. Thank you.
Thank you very much. It's a very relevant and topical question, actually. Well, the Temporary Protection Directive itself suggests that once the conditions for the displacement cease to exist, the temporary protection regime is over. So this is obviously a speculation. We're talking about some hypothetical situations that are very unpredictable and difficult to even imagine. Let's all hope that indeed is going to be the case and the war is over. There are durable, safe conditions there. But this is what the text of the legal tool is telling us. And as you know, drawing on other examples, we can actually see these being very realistic and very, very fast, which might not be really the good, perspective for the longer run for us. The difference here is obviously that, as we already discussed, we are talking about the group of people who have already freedom of movement, who have visa-free regime, and who now, years after, having been under the temporary protection regime, already are converting their permits into other ones. And Italy is one of the pioneering, actually, member state who was among the first one to adopt the law allowing the conversion of a TP-based permit into their employment one. And this is already happening in quite fast speed. I don't know if I answered your question, but it's very difficult to project the future. Unfortunately, I don't have any hints. Just perhaps to add something to that, we already see the discussion about the assisted return to Ukraine, especially to the so-called less affected areas. We know that there are already different international organizations advising, providing the information in the EU member states to the displaced person from Ukraine, providing legal advice and, this room for discussion and evaluation of potential assistance in the return. So I just want to flag that this is not something, that we are talking about as a hypothesis. This is something that is already taking place.
Thank you very much. If I can add a question to all the questions from the audience, I would like to know more about the Solidarity Platform, the way it works, and whether it was effective or not in providing, the right and effective match between the assistance provided by different member states, and whether it is still in place, still working, what are the prospects of functioning for the next future. So I would like to know a little bit more about this Solidarity Platform. And in addition, I am quite, interested in this idea of flexible solidarity stemming from the reform of the new pact, and in particular the reform of the Dublin system, because as you outlined in your presentation, it means a sort of mixed balance between compulsory solidarity, binding solidarity, and flexibility. But when I come to reading the reform, I don't see very much bindingness. I see just, a very complex procedural way to try to streamline the discretionary decision by the member states. But in the end, I don't see nothing comparing or comparable to the relocation decision September 2015 to make it clearly. So I would like to know what you see in the bottom of this paradigm of flexible solidarity, and whether this is just lipstick on a pig or something more pregnant, more relevant and more, productive, let's say so.
Thank you very much for these two really excellent questions. The first one about the Solidarity Platform. Well, I think I regret that I am not a Commission official or the Member State official to give more insight on that, because this is the platform which was coordinated by the European Commission, and only the representatives of the Member States have, and I believe up until now, have access to it. Again, as far as I know from my experience, in advocacy in Brussels and trying to have a contact with the policymakers in the area, with an exception of some also representatives of international humanitarian organizations and so on. Again, just to share my personal observation, it was rather difficult to get access to, from the civil society perspective, to the, to the functioning, to the insights, to the mode of operation of the Solidarity Platform. But the general observation that I can share, that it was extremely efficient tool, particularly at the initial stages of the displacement. As I mentioned, the meetings of the Solidarity Platform, of the various institution representatives at the EU level, but also the member states, were taking place on a weekly basis. This is really unprecedented coordination, and many issues arising from first ever implementation of these tools have been solved, coordinated, real time almost. However, again, I have to mention this limitation of the openness and transparency also to the displaced persons themselves, because I know that by civil society there was an attempt also to bring the voices of the affected, the persons affected themselves to share the first-hand experience, how this tool works, to inform the future decision making. It was quite restricted. However, I believe that the platform remains to be crucially important, particularly in coordinating the longer term options. I know that this is something that is being discussed there. We can obviously debate the efficiency and effectiveness of these discussions, because we are essentially still left without a common exit strategy out of the temporary protection, but it is functioning. And I believe this is really a unique platform for very efficient and speedy coordination. As to the reform of the Dublin rule within the new pact, and this combination with the fixed and obligation of the obliged solidarity, imposed solidarity, if I can put this, and a number of provisions that allow for the member state to resort to this flexible and voluntary approach. I am just here with you on that. I find the rules imposed extremely excessively complex, may I say somehow also unrealistic to implement, because the whole structure, the whole math behind it is extremely complex, and we need to understand that the situation of displacement is something that is occurring, especially in situation of mass influx, real time. Personally, I just struggle to imagine how all of these complex systems are going to, be implemented for the benefit of the displaced persons and in a timely and efficient manner. But I believe there is still room for hope. And I think it's also our responsibility, to remind constantly on every occasion. And I believe this summer training school is one of them, to remind of these positive experiences, and remind of this room and these flexible approaches that are still there left for the discretion of the member state, that they should be used, and they should be, and they will be ultimately really beneficial for all parties involved, I believe.
Thank you. Thank you so much, Victoria, also for this edition. Of course, I share your views. Let's stick to the bright side, even though it's not so bright in terms of implementation, at least because of the cumbersomeness of those procedures. Are there any further questions, or just one? Yeah, I kindly ask you to come here. Otherwise, for the recordings, it's not going to be efficient. So sorry for that. Yeah, take too much time.
Yes, thank you very much. Since you've been asking at the beginning if we think that it is a good measure, I would like to say my opinion. I don't know if others will agree, but I think that this marks our cornerstone taking a position from the Commission, because 20 years are many, as you highlighted at the very beginning. And I think that it aligns with the stronger position that EU is taking about asylum and migrations. And I think this is a very good place to start from, but the approach is soft, as we have been discussing, because it is a directive. So I think that this could be a good benchmark somehow, and a good practice, to say so, that I'm afraid we may need to reply soon, because we are in turbulent times at the moment, and the geopolitical situation is very tricky. So I'm afraid that the European Union will need to reply somehow the instrument. So I think that this could be a very scheme to start from, if we need, hopefully not, but if we may be in the awful situation to face other cases like Ukraine. And I think that what we may reflect is how to go beyond the temporary scheme, understanding how we can engage in a in the long run perspective, in order to give continuity to the support that we are giving. Because as we've been mentioning, we experience, and also by personal first-hand experience, I met some Ukrainians, asylum seeker coming in my town, and they have been involved in our daily life. They became friends of our children. So I think it's really hard for these people, especially for vulnerables and minors, which are in the growing phase and are building their personality. It's very hard to move again, and maybe because there are no concrete measures to include them permanently in the country they choose. I think this would be something to reflect, because it makes a great impact in people's lives. So I think that this is a perspective that may be taken into consideration. Thank you very much.
Yes, sure. I just want to also echo basically what you said. I completely agree with you. It's an outdated tool, in fact. Of the past 20 years, so many things have been changing, and obviously the implementation gaps and issues that we saw now with this implementation, one of them being, as you say, the lack of this coordinated exit strategy. Besides obviously the allowance to access all of the national tools, there is really a lack of some unified approach in the directive. Would be one of the factors to think about in the potential revision processes. And the last question from the chat, if I can.
Yeah, Adama, do you want to raise your question, please?
Yes, Professor. Thank you very much for this beautiful lecture. Really enjoyed it.
Apologies, but we cannot really hear you. I really apologize.
Adama, can you get closer to the microphone, please? No, I'm sorry, we can't hear you. And yeah, we can't hear you. Would you mind to? He can't hear us. We can't hear him.
Well, you're welcome to send by email your question, and I will try to elaborate. I'm very sorry, but we cannot hear.
I hope you can hear me now.
Try to speak. Yeah.
Oh, okay, I'll write it in the chat. I can. Yes. Can you hear me, Professor?
Unfortunately not. Maybe if you type your question. Yeah. I guess it would be better if you type your question. Adam, I'm sorry. If you type your question in the chat. Okay. Okay, I guess this is the best solution. So maybe Adama is going to type the question in the chat. So I want to say thank you again to Victoria for this exciting presentation and for, stimulating such a debate, excellent debate. It's now time to move on to the next speaker. And I invite Joanna here. So thank you very much for your patience. I know it's quite tough, but if we skip the break, we will finish on time. So I would like to move on directly to the second speaker. We have the pleasure to host here Giovanna Markiewicz Stanni. Yeah, I'm sorry, not very good with the pronunciation. Joanna is a doctor of law, assistant professor at the chair of theory, philosophy, and history of law in the Institute of Law Studies at the University of Zielona Góra. She is author of a lot of scientific works in the field of international human rights, international labor law, migration law, and published also, recently she published a monograph. So congratulations for this achievement. And she cooperates with several research centers, such as the Migration Law Research Center in the Institute of Law Studies of the Polish Academy of Sciences. She works also with the COSME project. She is part of the authors of the COSME book. And we are really glad to have Joanna here at the Summer Training School to complete the analysis of the Ukrainian case by giving the idea of the way in which Poland worked on reception and integration. So her lecture is titled "The Responsibility Sharing Options in Cases of Large-Scale Displacement Insights from Poland." It's yeah, I'm going to share the screen. Just a second that I close previous presentation and I open Joanna's one. And if we are lucky enough, this will work. Is this one right?
No, it is the previous one I have sent yesterday to Marilu.
But she did not upload it here. Okay. Yeah. So maybe, okay. So guys, differently from declared, we have to do a very quick break to upload the PPT presentation and we will be back. But please, it's not a 20 minutes break. Otherwise, we're going to finish extremely late today. Okay. So it's 5 minutes. It's 5 minutes. Thank you for your understanding. Okay, so welcome back. Seems we are ready with Joanna's presentation. So you should see our screen. Please, if you can confirm that you see the slides.
Yes, we do.
Okay. No, wait just a second. Okay. Okay, it's pretty clear also here in the room. Thanks a lot, Joanna. You have the floor.
Thank you very much, Daniela. It is my pleasure to speak to you today. Maybe I think that it is good idea to present you the more complex picture of Poland when it comes to migration and asylum generally. Why? Because it is helpful for you to understand the complexity of situation in Poland when it comes to foreigners and generally following it situation of Ukrainian citizens and other displaced persons. First of all, don't be offended, but Poland, it is Catholic country, white country, which means that we are a country of one nation, using the one language, one race. We are very unified when it comes to it. Of course, if you visit Warsaw, you meet a lot of people of other religions, other races, and so on. But if you go further to our country, to the countryside, to the province, you meet Poles, only Poles, using only Polish language. Of course, we are learned and education. We have education in the English language. That's why we are country. Why it is? Because we are country of emigration. For many, many years, people from Poland were coming outside, not inside. It is the first thing. The second thing is that when democratic changes were made, we started very slow to host foreigners. And I think that the moment of growing of number of people coming in inter alia from Ukraine was the time between 2014 2016. We until the start of war in 2022, Ukrainian diaspora in Poland was around 1 million people. There were men in a majority working, in construction, industry, and so on, but people who are similar to Poles when it comes to similarity of language, race, and religion. It is very important to understand Polish approach to this response to displacement. The second part of picture is very strict approach to people who are looking asylum in classical sense in Poland, individual refugees. Since 2016, around this date, Polish authorities introduced very strict policy which is systemic denial of receiving asylum applications when it comes to migration from every country. Why? Because it was a problem of changing of this kind of migration. People started show up, Pakistanis, Iraqis, Afghanistan people. This is a problem for Polish people, and I understand that it is not politically correct, but I think that I own you honest picture of our country. So, and in political debate and in political discourse, it was a lot of warnings, titles of press articles warning before asylum seekers from Middle East. And that's why until now, in Poland, we have some kind of double standard of treatment. People coming from Ukraine are treated as some kind of cousins, decent people, and everything is okay. But in connection with instrumentalization of migration from Belarus, we have a problem of fear before people coming from other than European democratic countries. And policy in this concerning these two groups is absolutely different. So it is important to understand how the picture of Poland is. So coming to status of Ukrainian citizens in Poland. The first is that we have, the first thing is that we have general rules applicable to all third country nationals in Poland. And these rules are applicable to people who has been living in Poland before the start of war. This caused some tensions between Ukrainians themselves, because people who has been living before the war feel that they are treated less favorable, that these displaced people are undeserved for such good conditions of reception. And it is the problem of division between these two parts of Ukrainians diaspora. The second group, it is there are people who are using and are in international protection. There are not such many people who got this refugee status or subsidiary protection. In comparison with other countries, there is, a very small number. And we have two special temporary protection regimes. Why? The first one is based on temporary protection under EU law, which was implemented to our act, which is devoted generally to international protection. Yes, and the second one, it is special one, established only by Polish authorities by our own will, to give Ukrainian people more favorable treatment than it is guaranteed under temporary protection. And as you can read, it is national regime existing alongside of EU mechanism. What is very important, you are not allowed to use those two regimes. You have to decide. From time to time, maybe I will add something later. It is not necessary now. Maybe I will go to the next. Let me check. Maybe this third. Data and numbers coming precisely to this time. If you can see, in the wake of Russian aggression to Poland and entered around 3 million people in very short period of time. It was first 2 months of the conflict alone. At this time, Polish border guard, which is generally very strict, was very flexible. If you wanted to cross our border, absolutely everything was acceptable for Polish border guard. What I mean, for example, normally you need passport, visa. On this specific time, it was, for example, enough to show, your driving license, your birth certificate, everything what could prove your identity. When it comes to children, for example, only testimony of caregiver, because it was emergency situation, absolutely emergency situation. You have pictures from 2022 to the period 2024, 2025. You can see that the number of people actually living in Poland and be covered temporary protection is lower. Why? Because many people decided to go to their relatives or to other countries. Some decided to go back because, for example, it was west side of Ukraine and the situation is better than in Kharkov or other part of east part of Ukraine. So we have different numbers because, every entity, every international body has his own method of counting, but generally it is around of million people. And if we add this 1 million men working and women working before the war and children, from time to time people say that generally Ukrainians living in Poland, it is the number around 3 million. But it is not precisely, because it is very fluent. People go and back, forth, and they losing a status from some reason why I will explain. What is important that the structure of migration before 2022 and displacement is completely different, because here we have women and children absolutely as a majority. So the needs are completely different in comparison with this work employment migration from previous years. And most of them live in urban centers. It is classical that they are in our cities. Maybe some picture of which rights are connected with temporary protection. I will explain how to get it. So what is important from the side of Polish society, Polish society view, it is national treatment in terms of access to social and health care and education. That means that if you get some specific number, because if you want to get temporary protection, you have only one thing to do. You have to go to our local office to prove that you entered our border after the date of outbreak of conflict, and to show that you crossed the border legally. It is interesting, but it is very simple when it comes to this procedure. It is near to you. Local authorities, local authorities hired so many people to to help Ukrainians to fill application in Polish language, because our languages sounds very similar, but we have different alphabets. And it is the problem for Ukrainians to read Polish language and from the other side. So education and healthcare. Why I make emphasis when it comes to healthcare? Because in Poland, as as in many countries in Europe now, there is rhetoric, very not good rhetoric, that Ukrainians, take something Polish citizens. In Poland, we have a problem with very long time of waiting to doctor, to specialist, for example, with heart problems and so on. And some politicians use this problem to show that, oh, you can see Ukrainians replace us in these queue lines to the doctors. It is absurd, of course, but many people in Poland follow this, this specific discourse, and it was very, very strong, emphasized in a campaign this last month when it presidential campaign was made. When it comes to education, Ukrainian children has absolutely free access to education. Which problems we have with it? Of course, language, because we employed some people who are teaching with some kind of preparatory classes to prepare Ukrainian children to study and learn in Polish, but it is not enough, and we observe some tensions between parents of Ukrainian and Polish children. Why? Because Ukrainian pupils are not, able to learn so quickly due to this language issues. To learn so quickly as Polish pupils. So some parents are not satisfied, not happy that we have Ukrainian children in our class, because there is no formal, absolutely obstacle to go to the Polish class, and there are some pupils and students in some classes. But I can share with my specific knowledge. For example, in one of Polish schools, we have one class which is only Ukrainian, but teachers are Poles. And they struggle how to communicate in good way, how to teach, biology, genes, and so on with pupils who understand you in very, very limited way. Why it happened that we have situation of the class only for Ukrainian pupils? It wasn't, aware, but when it comes to things happened. It wasn't not direct goal of Polish educational authorities. So, right to work and run business. Access to labor market is free to a large extent. If you want to work in Poland, the one condition is that your employer have to notify, has obligation to notify our labor office. The period of notification is 7 days. Which problem we see that not all Polish employers notify labor office. Some Ukrainian people are absolutely exploited. They are, because there is no notification, there is no obligation to pay a remuneration. in the level which is guaranteed in our law. But what is good, I think, that a policy of our government is that even though Polish inspection of labor law discover people who are illegally working and they are Ukrainians, they are not fined for this reason. There is no sanction, but only employer is fined as this situation. Of course, there are obstacles connected with Polish language, because if you want to work in the supermarket, of course, immediately next day, please welcome. The problems start with positions connected with good knowledge of Polish language. I will show you next how which problems we can see with it. Generally, it is more in detail explained this condition, entitlement to work in Poland, this enjoyment of special protection in Poland, staying legally in Poland, and this it is written on slide that you have to obtain the a PESEL number. It is this registration, because PESEL, it is generally register of Polish citizens born in Poland, and we add this UKR letters to differentiate Poles and Ukrainians having this temporary protection, and it is made, as I said to you previously, very simple procedure, and you have this UKR, and it is only this one thing. It is proven. No any document, to prove that you are covered by temporary protection. Yes. What is interesting for you, and my introductory remarks were needed, that this special temporary protection is applicable only to Ukrainian nationals. It is the first thing. So, citizens precisely. Yes, if you, for example, before the war, you have been living in Ukraine and you were from, for example, Macedonia or Moldavia, you are not covered by this. You don't use this advantage of special national protection. You can use this EU protection, but this special act established only for on the territory of Poland is only devoted to these people. And what is interesting, that it is applicable only to these people who reached Poland on or after 24 February. Due to the war in Ukraine, and some of their non-Ukrainian family members, spouses, the closest family. I will explain what means a Poles card. In Poland, taking in mind our very complicated story, we have had a huge emigration, and there is many Poles living, for example, in Kazakhstan, in other Asian countries, when they have Polish roots. They are speaking Polish. They have Polish ancestors, but they have not Polish citizenship. And for those people, our state make some document that you belong to Polish nation, and even though you have no citizenship, this legal bond with Polish state, and they take advantage to be connected with our families and our nation. So it is applicable also to children of Ukrainian nationals and of their spouses. Of course, it is situation when the child has no citizenship of Ukrainian citizenship. For example, it is a citizen Moldavia and other countries. So the element of family links, it is enough to cover this person special protection regime. And the very important thing is this entering Poland legally. You can be surprised because what is the problem? From time to time, due to complicated things on the front and these battles, people were coming illegally from the Belarus to Poland, and they showed up on our territory without notification of border guard that they entered our border, and for this reason they don't take advantage of this special protection. The most difficult problem is with stateless people, because as far as you know, maybe Ukraine has one of the highest number of stateless persons in Europe, and these people wanted, as others, to have refuge in our country, but Poland is not a member state party of any international conventions regarding statelessness, and we have no formal procedure to confirm that person is statelessness. So the only way to prove that you are stateless, it is special document concerned issued by UNHCR and other entities. So it is very problematic because people are in some kind of legal limbo in Poland in this situation. Yes, and maybe if you are aware who is covered, you can easily find who isn't. Yes, holders of a temporary resident permit, permanent resident residence permit, and EU long-term resident permit. Why it is important? Because Polish authorities has a plan to change. It is answer maybe to our discussion previously made that Polish authorities has a plan to reshape, to make transition from this asylum seeker, refugee people to members of our society using solutions which are general applicable to foreigners. And our authorities introduced some changes to our law, making easier to Ukrainian citizens covered international this temporary protection to have access to this legal status without being asylum seeker of any person which is protected. But the problem is that we are struggling a lot with inability of our administration to proceed. could you imagine that legalization of stay in Poland, the maximum long period discovered by our institutions, was around 3 years. You know, it is if you come to studies, for example, to university, you could finish your study and your legalization procedure will not finish. Yes, it is absolutely horrible situation. That's why in the law, it is written that you can may apply for residence card. It is very good because it is period of 3 years, but now it is not possible to apply because there is no specific regulation making it in practical way. And the second thing is that Polish administration is in protracted lengthiness, and it takes ages to make your status legal in Poland. We have some firms and entities specialized only with legalization of stay in Poland, because for normal people is, you know, too harsh. It is Mount Everest, and you can give this to other professionals. So maybe next thing, because I am too. Maybe this it is very interesting for you because it is some answer how it looks, this process of receiving of people when mass displacement is happening. The first couple of months was, we can say that it was spontaneous assistance stage. I was so proud when everything happened, that I can say honestly that everyone who I know was involved on some activity. Everything, food, you know, clothes, accommodation, pick people from the border. I know people who are, I am from the western part of Poland. It is 600 kilometers from our east border. But people came from Zielona Góra to to Terespol and other parts of border to pick people and offer them lift to Krakow, to Warsaw, and so on. People send medicines to Ukraine. Also, you know, this soft military equipment as well, because Poles wanted to be engaged to help on every level. When it comes to, and this I think that it was a very spontaneous, natural movement of people, organized by people themselves. Local authorities focused on that time with organization of a short accommodation shelter, because it was very important to give people accommodation after this long waiting to be entered in Poland, and give them food and so on in this first couple of days. And it was generally this activity. And general and central government was focused to organize, you know, the legal framework, because everything happens before the law, yes, was established. So the second stage was adaptation stage, and people who was so spontaneous and so much involved, a little bit took step back and it is natural that we needed, this long-term and institutional state action. And it was very, very good to see, to observe that, for example, people spontaneously offered Ukrainians their homes free of charge. I will show you the numbers. And it was spontaneous, warm heart and so on. But after 2 days, tensions were coming, and it is cultural reasons, language reasons, everything that, oh my gosh, it is too much for me because these people have no money to buy something. It is normal. Imagine that from tomorrow, you have very absolutely strangers at your home, and there is, for example, family with 5 kids, yes, and people discovered that, oh, it is too much, and it was natural process of this withdrawal of this citizen involvement to these long-term actions. And for this moment, we can say that Polish state started to support this accommodation activities and to support generally status of helping of every organization helping fugitives. And the integration stage, I think that when we think about it, from maximal flexibility to more strict approach. What I mean, for example, in the first couple of months of this displacement, you could, as I said, you used every paper, every document to prove your identity. But the law has changed, and now you have to show only international travel documents, which means passport. Yes, and some people assess that it is too early because this change was made in 2024, but it shows that, okay, this is stabilization stage. We can demand more than previously. When it comes to period, when you go to the local authorities to get this UKR number, previously you have had 30 days to show up. Now it is an obligation to show up immediately after the entry of Poland. So there are pieces of things which show us that, of course, we were flexible, but now we are coming to our stricter dealing with things when it comes to foreigners. Yes. What is specificity of a Polish resettlement, Polish approach to resettlement is that generally we have no camps, no this collective accommodation approach. What means that generally, as you can see, it is very high number that 93% of people are living privately in Poland, which means that they are renting a flat. And from in the beginning of war, numerous Polish citizens, as I said, offered their houses and apartments to displaced persons. we have no such precise data because it was spontaneous. It wasn't registered. You know, it was some kind of Facebook things and personal meetings. It wasn't official things. It was very spontaneous. So economic research show that probably 7% of people involved generally in help and assistance to Ukrainian people gave this opportunity to make accommodation, to use accommodation free of charge. And it was, you know, sometimes it was very short period of time, 2 to 3 days, and from time to time it was transitioned to longer period. So next. And of course, it doesn't mean that Polish authorities left other people who couldn't afford, for example, rent our apartment without any help. But we can say that this is specific. In Poland, it is rather an exception, not a rule, what I want to say. The short-term accommodation, it was mentioned before. Long-term accommodation facilities were also established. They are called in Polish language, collective accommodation centers. They are run by voivodeships or other local authorities. And it is not the same because in Poland we have specific accommodation centers for people who are in classical international procedures, asylum seekers from other countries, but this is not the same thing. This is now it is, as Victoria showed you before, you can live there for free for 120 days, but after that co-payment is required. We have some exceptions for the most vulnerable people, which means that it comes to women with many children. They are not able to engage in any economic activities, and that's why they are exempted for this payment. And number of people in collective accommodation is constantly decreasing. You can see that these numbers, and for this reason it is a plan to close generally this collective accommodation, and maybe it should be done in the next change and of our Act on Assistance to Ukrainian Citizens, because generally there are Polish government withdraw when it is possible from costs connected with Ukrainian citizens. And what was mentioned by Victoria, that to support these people who assisted Ukrainian fugitives by this renting flat for without charge, it was solution in Polish law that, okay, if you provide accommodation and food, which is very important, because in Poland it was compulsory to give this food. If you don't give a food to your guests, it wasn't possible to get this this benefit allowance, as we can say. But what maybe I will explain the amount. Okay, 40 zloty. What does it mean for 40 zloty? It is around 9 euro. In Poland means that it is around 3 couples of coffees in good cafeteria. So if you can make a shopping, for example, yes, but you know, it is, I don't know, maybe bread. Oh, bread is also good. I buy bread in nice bakery, and one piece of bread is 10 zloty. So 4 breads, of course, very fancy. I like bread. You know, this is amount which show you this amount. But after 2 years of this support, government withdraw and repealed this support, arguing that this is not a lot of people involved in generally Ukrainians are independent now, and it is not necessary. And what is important that our government think about how to do how to make people more independent as it is possible. We don't have this approach. It is not wrong with this approach, but I can say you, I can tell you about it. Yes, that in Poland this is a fear before German approach to asylum seekers. Oh, you are asylum seeker, you have benefits, you cannot work, you have rights, and with obligation is a more complicated thing. No, in Poland, people are accepted so much because they are involved in our economy. They are our co-workers, and the government plans to get them to our society, but it is the very important challenge, I think, which is connected with Polish language. I will explain maybe later why. I will follow to the end. You know, this is the sentence, exhaust a topic, not exhaust listeners. So, oh, yes. How many people, not in maybe not people, because there were, for example, some small businesses which offered this free accommodation. These are numbers from only these years, because I didn't find data from 2024, and this was, you know, cut in the middle of year. But what is interesting, that research suggests that it was 1/3 of general majority of people who gave this assistance. So we can suppose that around maybe 2 million people gave this kind of support to Ukrainian citizens in more or less. Why we know it? Because if you wanted to get this allowance, you have to fill this application, and the number of these applications give us this information about the number of people potentially who gave this kind of assistance. Maybe I will go to the challenges. Challenges related to current situation. The first one I mentioned before, the lengthiness of administrative proceedings conducted generally when it comes of legalization of everything which happens when it comes to foreigners in Poland, independently when it comes to USA citizens or German citizens, maybe or Ukrainian citizens. The structure of opportunities for adults to learn Polish is not enough developed. So we have no so much places when adults can go and can learn Polish language. Why it is so important? Because Polish policy, Polish government doesn't accept assumption that in Poland could live people doesn't using Polish language. I have to be good, well understood. Knowledge of Polish language, it is meant as a condition to be here as you know condition of good integration. So it is not good, not bad idea, because generally Polish people are not so well educated, for example, as Swedish in English learning. So it is difficult to communicate with Poles without knowledge of Polish language. Limited access to exams, proving knowledge of Polish language. The problem is that many Ukrainians learned Polish. You know, there are many similarities. If you are working with Poles, you have a good opportunity in short time to learn Polish. But we have only dedicated, specially proven by ministry to make exams. And they make these exams not too often. And could you imagine that when they open, you know, this window to fill, to make submission that, okay, I will take this exam, it takes a minute. And there is no place. I don't know, but this is the knowledge from my colleagues from Caritas organization, which is involved in Polish in assistance to Ukrainian citizens. So it is absolute need to open more centers approved to make exams, certifying the knowledge of Polish language, and it could be more accessible. It should be more accessible than now. The next problem is low recognition rate of qualification in diplomas. It is due to the difference of education of all levels. As anecdote, my colleagues told me that our friend from Ukraine was advised that maybe it could be better not to prove that he has habilitation in Ukrainian, but to write new book and make process in Poland and this habilitation process, and it will be quicker than, you know, the proof that, okay, we recognize that you got the professora habilitation in Ukrainian. So lack of formal representation in the frame of relationship with authorities. It is my personal experience that I have colleague and I am a part of some kind of team working with development of Lubuskie Voivodeship, my voivodeship. And we wanted to speak with Ukrainian diaspora about their problems, what they need, and so on. But they are divided. There are some societies, organizations, but if you ask me legally, to whom I am obliged to speak, it is not cleared in the law. And from time to time, it happens, for example, that we invite, it happened 2 months ago, that one organization was invited and the second was one was invited, but when they get knowledge about, you know, the presence of the same time, no, if he will show up, I will know. Okay, but there are personal issues, but it would be fantastic if it would be solved. And the last thing, increasing a commercialization of assistance made by Ukrainians to Ukrainians. They said to many people, okay, knowledge costs money. If I learned how to, for example, fill some application for some benefit for children, pay me, I will fill it instead of you. But, you know, this one sheet of paper, it is cost of fulfilling this of about 50 euro. And it is for Paul, it is, you know, 5 minutes, yes? And it is a problem because these firms, organizations cheat. Why? You have two entities registered under the same name. The one name is charitable. We give you support and of course, and everything is free of charge. But in some moment, you are under protection, the entity, which is business, and your next service, your next application is charged. You didn't know it previously, but it very often happens. And when charitable organization or for example, public governments offices wanted to, for example, announce something on Facebook, wanted to get these people, okay, you will pay for it? No, because we are public officials. We want to help you to make help your Ukrainians colleagues and you know, member states. Okay, but it is our Facebook and no. So I hope that I made some vision of Polish approach to resettlement, and I think that it is round to make questions.
Thank you so much, Joanna, for your presentation and adding another piece of information to the analysis we started this morning. Indeed, it's now time for the Q&A. Let me check the chat. I don't see hands raised for now. So let's see if there are any questions from the floor here. Yes, would you mind coming here? Because I don't know.
Can we see if there is a problem, like me speaking?
Okay, maybe we can hear you. Yeah,
Yeah.
okay.
Hello, my name is Erekle Gobladze. Thanks again, because the previous days we had the chance to get like some institutional side of refugees resettlement and also community sponsorship, but you have this first-hand experience and you shared with us this everyday struggle and problems of Ukrainian refugees in Poland. So thanks for that. Well, my question concerns the education. You said that there is a problem of Ukrainian kids not knowing that well Polish, besides the fact that Polish and Ukrainian are indeed similar in a way. I want to know, because I'm from Georgia, and in Georgia we have, in Tbilisi and in Batumi, we have two schools, public schools, that have Ukrainian sectors. And there the school program is approximated to Ukrainian one with some details added in for Georgian context. Do you have something like that in Poland too? Because I get that for integration it's better if a kid is integrated in a fully Polish society and community, but I think that for the beginning, it would be nice to have something like that, like a Ukrainian education system, maybe. Thanks.
You want me to collect some further questions, or would you
Okay.
prefer replying directly?
Maybe short. We have some kind of there is no possibility to make only formally, you know, this only Ukrainian class or a division, but we have some preparatory classes. And they are meant to prepare Ukrainian children to study and learn in Polish. But it is not, I think that it wouldn't be good idea in Polish perspective and Ukrainian perspective, this only Ukrainian thing. I don't know how to call it in English, so.
Yeah, I understand what you're saying. I mean, I agree that it would be nice if a Ukrainian kid would be just integrated in the Polish.
Yes, what I can add, the problem in Poland was that for the first year, absolutely, and I think that the second year to the half, that Ukrainian children were allowed to make education remotely. But Polish authorities oriented that we have no, full control of about this education, because parents who go to work and kid is this before the screen, and and there were a lot of situations when people made statement that they have children and they are going to school, and this didn't happen. And that's why in Poland now you can get benefit for a child as a Polish citizen, but only when you have proof that that this child attend Polish education. Because of this cheating, no child, for example, but you go to the local authorities and state that, oh, I have a child going to school. Yes. Okay.
Thanks.
One is
Stateless are given. Yes. Sam Sidin Jarju. I'm sorry if I mispronounce. The problem is that when, of course, from formal point of view, stateless people, if you are fulfilling conditions of international protection, which means individual prosecution, and you are coming from the country which your life or is endangered and so on, of course you deserve protection and have protection as asylum seekers with some citizenship. The problem is practical. The problem is practical because if you have no citizenship and no document to show that you are stateless, for Polish authorities, it is a big challenge. You are in this legal limbo and probably you will be deported in some time. So I can share you maybe I will note it that I can share you some expertise about statelessness in Poland and how it is difficult to be stateless in Poland, and this low there is a low recognition rate when it comes to stateless people asylum status. Rejoin. Could you please? This is not not question. I think. Are there? Adama Silla. Are there no of rights?
Let's read the question. Let me read
Oh.
the question because otherwise some people don't know. So are there different classes or tiers of rights created between asylum seekers and displaced persons? So whether there is, I mean, the same rights, there are the same rights or different rights between asylum seekers and displaced person. And I also read the question by Manasseh. With language and religion as standard blocks, what likely to affect the Polish integration mechanism to migrants Ukrainians? I don't know, maybe you want this question to be clarified by the author. Yeah, so Manasseh, get ready to take the floor in a minute. I leave the floor to respond to Adama and then we get back to you.
Of course, there is different situation, because if you are asylum seeker in Poland in procedure, you are not allowed to work, for example. You have other, it is not a problem of education, but if are legally in Poland, children are allowed to learn in Polish school, but asylum seekers in Poland are living on their own. If are, of course, you have some benefits which are connected with your status, but generally there were no such support when it comes to temporary protection and Ukrainians. We have situation in Poland when asylum seekers are living in some centers for years because they are not able to live alone and independent outside, but it is different story, because it is not so simple for asylum seeker with recognized asylum seeker to work in Poland when it comes to Ukrainian citizens. It is different story.
Okay, there is the last question. Let's see if Manasseh wants to take the floor. Yeah, he is ready.
Yeah, thank you. I think my question is just asking about these gaps, because when you look into the aspect of religion in Poland, it's kind of more strict, and the more Christianity being the core, and probably blocking other religions from access to integration, and also the aspect of language, as the presenter just talked about. So how do you think this will likely affect the integration aspect, especially to institutions like schools, and also to the general community in Poland?
I think that the language and religion, I think that we should differentiate between society and state, because Poles are, for example, when it comes to this language, it is the first time in Polish history when I see on the streets something written in other than Polish language. For example, you know, when shops, advertisements, yes, and reklama. Advertisement. Yes. Many communication at public transport. There are many written information in Ukrainian language. Every university in this country has a separate website with Ukrainian language. There are many entities with this special unit which is dealing with information for Ukrainians. Translators were hired. So I think that the Poles made a very huge effort to make and feel Ukrainians comfortable in Poland when it comes to every I don't know, every part of life. For example, when you will come to the doctor, you will receive information in Ukrainian language as well. On the tables, on the doors, for example, how to prepare to the examination and so on. When it comes to religion, maybe it is not so important in this way of thinking that Ukrainians are not so religious, and I don't observe so many problems to solve when it comes to. Maybe everything is coming to understand each other, and what is in perspective for me to avoid this danger to think that Ukrainians are privileged people who take advantage, undeserving advantage to be Ukrainian in Poland. If we cope with this, I think that the future is not so bad.
Thanks a lot. Joanna, are there any further question? I don't think, I mean, not from home, maybe here.
We deserve lunch.
Yeah, no, I see, I understand that everybody is quite tired, especially because of the weather. It's really hot. So I guess we're perfectly on time, so we can close the morning session, and we are going to resume this afternoon at 2 to conclude the second training. So have enjoyed lunch break and see you in a while. Thank you.
Thank you.